Mock trial involving a local government that was sued because of a highway accident. The mock trial is based upon an actual case that occurred in Pennsylvania. I'm Walter Kilareski, and I'll act as your moderator. Listen to the judge's instructions and the testimony of the witnesses. At the end of the trial, the jury will deliberate the negligence of those involved. We would like you to do the same. In your session, you'll have a verdict slip to record your opinion and the reasons for that opinion. Let's begin the trial.
I'm going to talk just very briefly about trial procedures, just generally what you should expect in a trial if you're going to be involved in one, and you'll see what happens here. Not everything's going to happen here as far as a trial will go, but I'm going to go through the procedures just in a very general, brief way. The first part of the trial would be the jury's selection if it's a jury trial. Sometimes you have a trial that the judge is both the finder of fact and the determiner of the law. Generally, you want to opt for a jury where you have 12 people who can make a decision rather than one person. And particularly if that one person was the end of the lunch line earlier on and didn't get only got a little bit of a sandwich, so you may have somebody who's not really feeling too well, whereas that can be diluted with respect to a 12-person jury. The purpose of the jury is to hear the testimony and determine what the facts are based upon what they hear. You're going to hear a lot of different things, but you're going to have to make a determination as to what the truth is, what those facts are. And the judge's responsibility, my responsibility here, will provide you with the law, and then you will make an application of the facts to the law. You look at I'll give you the law, you look at the facts, and you see how they mesh to see who is ultimately responsible. That's basically what a jury does. Sometimes you'll have what are known as stipulations of facts or admissions. We'll have some in this case just to cut things short, but it's basically what both sides have agreed upon, and the jury will be made aware of that. You'll have an opening statement by the attorneys to the jury to kind of lay out what the case will be. So you have an encapsulated summary of what's going to happen in the case. Then the plaintiff, Mr. Rosenthal, will present his case first. He'll call witnesses. You people may, even though you are representing defendants, you have the potential of being called by a plaintiff in their case, and you could be called as on cross-examination. Now, the difference there between answering a direct question or being called as on cross is as follows. A direct question would be something like, well, what did you do on the afternoon of January 19th? And that allows you to explain what you did that afternoon or what your crew did that afternoon. A question as on cross-examination would be, isn't it true on the afternoon of January 19th that you didn't get to the intersection of Route 13 and 132 until 4:30 in the afternoon after spending the early morning hours cleaning brush at a particular intersection? That way, instead of you being allowed to frame and answer the question, it's framed for you, and you're boxed in, and you have to answer a yes or no or whatever. So it's a big difference if you have to answer it on direct or if you have to answer it as on cross-examination. That can be done sometimes. So all of you may be in that situation if you're ever a witness. You have, basically they're called, that you still beat your wife type questions. I mean, that's how your cross-examination questions can come in. And then the plaintiffs may have your expert witnesses. And we've heard something with respect to that. At the end of the plaintiff's case, the defense attorney, Mr. Capuzzi, would make a motion for what's called a compulsory non-suit. And in essence, he will get up and say, okay, you've heard their case. They haven't made a case against us. And the judge would make a ruling whether that's true or not. It's very rare for that to happen, although Mr. Rosenthal informed me that has happened to him in the past. So then what happens is, the defense will call their witnesses after I would deny the compulsory non-suit. And that's mostly you. You can be the witnesses here. And this is where there's things you heard about before the break, the discovery, the depositions, the answers, interrogatories, really come into play, because being used by a good attorney against you, it could be a club that could beat you, bludgeon you, knock you down, and then can be a sword that can rip your heart out if you haven't done it right. Or if you have a defense attorney who has adequately prepared you both before the discovery and for the trial, it can be a platform upon which to build the case. So everything that has occurred before is coming to a culmination now. And the discovery that you've gone through and that you've participated in is going to be the basis of your case. You'll also have, in both sides, not just the defense side, demonstrative evidence, blow-ups, photographs, things like that. Those things will come into play throughout the trial. You can call, or your attorney can call, the plaintiff as on cross-examination, just as I explained that a defendant can be called, a plaintiff can be called too. Couldn't happen in this case with great effectiveness because the plaintiff is dead. His representative could be called as on cross-examination, but he wasn't involved with the accident, so you lose something there. Expert witnesses also are called by the defense, and you can be expert witnesses. It's not uncommon for somebody such as yourselves who work in this field to be an expert witness yourself. I've done that myself in the past. And the standard, at least in Pennsylvania, I don't know how it is in other jurisdictions, is you only have to have a reasonable pretension of knowledge in an area that's outside the ken of a layperson. So, you know, if you have a particular knowledge in a particular area, you can be an expert witness. Again, you don't have to be a PhD or have any advanced degrees to do that. After the defense case is put on, then there's a chance for the plaintiff to come back with a rebuttal. If anything comes out in the defense case that he had not been prepared for earlier on or needed to comment upon, it could be brought out in a rebuttal, a very short rebuttal. That's up to the discretion of the judge. It won't happen here. And then at the end of that, you'll have the defense asking again for another motion. And this is a motion for what's called a directed verdict. And he gets up and says, look, Judge, you've heard their side. Now you've heard our side. You've heard everything. You want to let us go? You want to let us out of this case? And again, it's rare. The judge will usually opt to let the jury decide, and that's what's going to happen here. That'll go on. This is, again, Wellington County. You saw how jury selection was. I just dragooned these people, pulled them out, and put them here. In Wellington County, I set the jury instructions myself, but in real life, the attorneys get together with the judge, and they go over the instructions on the law that I will give to the jury so they can make a determination as to what law to apply to the facts. That's another stage, and this is often causes a delay in trial that drives jurors crazy, but it's necessary. After that's all determined, then there's closing arguments, and we will have short closings where both sides will give you your pitch, and we'll say their pitch to you, say, look, this is what we feel is important in this case, and this is why you should vote in our favor. After that, I will give the jury instructions. I'll tell them what the law is that should be applied, and then the jury will reach a verdict. So that's basically, in a nutshell, the procedure that will be followed. Before we get into this, I want to tell the jury here, and you out in the audience, what facts have been agreed upon. So there's certain things that are already agreed upon by the parties, and then you're going to make a determination as to what other ones you will agree to or adhere to. But here's the stipulation that was reached. This accident occurred on 6:45 a.m. on October 20th, 1988. The plaintiff, Mr. Robert Wilson, deceased, was traveling eastbound in a 1986 Chevy pickup truck on a roadway in Lincoln Township. It was still relatively dark at that time of day. The roadway was dry, the visibility was good, and the road was straight with a gentle slope. Several hundred yards of sight distance was available to Mr. Wilson. On the road surface, there were short dashed lines that separated the east and westbound lanes. The road was owned by Lincoln Township. It had recently been paved by the defendant, Meyer Paving Company, who had been hired by Lincoln Township. Now, it is agreed by the parties that the plaintiff, Mr. Robert Wilson, attempted to pass 3 vehicles on a downhill slope. As he was passing the third vehicle, a dump truck, both of his left side tires left the roadway surface and encountered a 5-inch drop-off, or a difference in elevation between the shoulder and the road surface. Mr. Wilson's vehicle then moved to the right and entered the eastbound lane in front of the dump truck, and before encountering a 5-inch drop-off on that side or the other side of the roadway. At that point, after encountering that drop-off, it proceeded back again to the left, crossed over both lanes of travel, sliding sideways at this point, before leaving the roadway and striking and shearing a utility pole and eventually turning over. And Mr. Wilson died as a result of this accident. So that's the stipulation of facts that the parties have agreed upon, and counsel, are we ready to proceed? Mr. Gates, you're under oath.
Good afternoon, Mr. Gates. Please state your full name for the record.
John P. Gates.
And where do you reside?
I reside in Wellington County in the town of Lincoln.
You a township supervisor?
Yes, I am.
How long have you been a township supervisor?
8 years.
Is it true that you were one of the township supervisors that signed the contract with Meyer Paving Company, which permitted them to place a 22-foot road through the borough, actually a job where they went through past the borough building on the old Route 115 in Wellington?
Yes, I did that.
Okay. And that particular contract required 3 township supervisors?
There were 3 township supervisors that signed that contract.
Now, as township supervisor, your responsibility is not for roads, is it? It's for maintaining the police department.
That's correct.
And at some point in time, after this contract was entered into, for a 22-foot road to be in the place of what had been an 18-foot road, you were called to out to the roadway by a Meyer Paving Company employee, were you not?
Not exactly, but I was called out there. I can't remember exactly who called me, but I was called to go out and see the road.
And when you went out to the location, were you on the roadway that's depicted in the photograph shown on the easel?
Yes, I was.
And when you're on that particular roadway, on the date that you went to the scene, which eventually would be the accident scene where Mr. Wilson died, were there 2 berms, one existing on the right side of the road and one existing on the left side of the road for traffic as they traveled on that roadway?
I'm sorry, could you repeat that, please?
Sure. When you went out on that day prior to this accident, some point prior to the accident, to meet with a Meyer Paving Company employee, were there 2 berms in existence, meaning a shoulder adjacent to the roadway which contains lateral support for the roadway and is an escape route if vehicles leave the roadway?
Counsel's testifying as to what the conditions were.
Overruled.
Please answer.
There was a shoulder on each side of the road.
Now, you were out at this scene with Mr. Meyer from Meyer Paving Company. Is that not true?
Yes, I said I was.
All right. And when you were out there with Mr. Meyer from Meyer Paving Company, was there a conversation where it came about that you gave the go-ahead to reduce the road lane width from the 22 feet that was contained in the contract to 18 feet?
I had a discussion with him, and we did. I said yes, to go to 18 feet rather than 22 feet.
And did you come to the understanding through your conversation with Mr. Meyer that by reducing the work zone from making it a 22-foot wide roadway to an 18-foot wide roadway, that there would be berms on each side of the roadway which would now no longer have material in them, and you would create through this contract an artificial berm drop-off on each side of the roadway?
It was my understanding that there was a possibility that there would be probably a slight drop-off on each side of the road. Is that your question?
A possibility of a slight drop-off in the road?
That's right.
Well, this roadway was being overlaid with bituminous material. Is that correct?
That's correct.
And when you were out there, you were told by Mr. Meyer that you have a situation where there already are shoulders lower than the roadway. Is that correct?
That the shoulders were not able to support, that they'd break off or something like that if they put the road on, and so we had to make the road narrower. What we did was made the road the same width that it already was.
No, you're not answering the question, sir. Were you told and shown that there were berm conditions that were substandard to the height of the roadway when you were out there with Mr. Meyer. He showed you that you already had berm drop-off conditions along this roadway where you had an 18-foot road to begin with. Is that not correct?
That's correct.
Okay. And then he told you they were going to put a 2.5 or 3-inch overlay on top of the existing roadway surface. Is that correct?
2.5 inch, yes.
All right. So you have 2.5 inches on top of an already existing substandard berm condition. So what you have is you're increasing the difference between the berm area and the roadway. So the vehicles go off the roadway, they will encounter a change in height between the roadway and the berm surface. Is that not correct?
I know that now. I only knew that there was going to be the pavement on top. I didn't think of putting the two together.
You're a plumber by trade, are you not?
That's correct.
And you've never been trained in how to maintain a roadway, have you?
That's correct.
Yet you made a decision which had to do with the how people operate vehicles on the roadway in your municipality, which could involve life and death decisions. Is that not correct? And allowing the berm to be existing at a level substantially lower than the roadway, even though that the contract called for a 22-foot wide road.
I didn't know that there was a safety problem tied to it, no.
Sir, I'm going to show you two photographs. Now, one photograph shows the roadway scene and my client's vehicle turned over after impact. And it shows a roadway. And I don't know if you can tell the difference in height between the roadway and the berm area. But it's been agreed upon by both your counsel and myself, and the judge has agreed with the stipulation that there was a 5-inch difference in height on the right side of the roadway and on the left side of the roadway, meaning any vehicles which left the roadway would encounter this drop-off. When you've driven on roadways, have you ever encountered a berm drop-off before?
No.
You've never encountered you're 42 years of age, aren't you?
Yes, I am.
And in the years that you've been driving since you're 16, you've never encountered a difference between the roadway height and the berm that's caused you concern when you're operating a vehicle?
Just typical go off the road once in a while in the truck, but nothing that I really noticed much.
Does that concern you when you go off the roadway?
You slow down, and yes, it's...
In fact, you've seen signs that say low berm or soft shoulder for the years you've been driving a vehicle, haven't you?
I've seen soft shoulder signs.
Yeah. Have you seen low berm or low shoulder signs also?
No, I've only seen soft shoulder signs.
Do you know why those signs would exist?
I presume that they're to warn me not to go onto the shoulder.
And why would they want to warn you?
Because they probably it would be a problem. There would be a safety issue.
Be a hazard, wouldn't it?
Yes, sir.
Okay. And you're telling us today that you had no knowledge that by changing the difference between the roadway and the height of the berm, that a hazard would be created. Is that what you're telling us today?
I'm aware now, today, that there's a hazard. I wasn't aware at the time.
I'm going to show you a document. It's from the Township Board of Supervisors of your township. It's dated October 12, 1988. And it's signed by the Borough Secretary, and it's to the Meyer Paving Company. And it says, this letter is to confirm receipt of your letter dated October 11, 1988, regarding the meeting between Mr. Gates and Mr. Blank to pave the above referenced project. After inspecting road conditions, it was determined that due to the incomplete and lack of ID2 paving on edges of the roadway, it was decided to pave a width of 18 feet 0 inches as opposed to 22 feet. Was that your decision, sir?
That was my decision.
Okay. And were you the one who directed the Borough Secretary to send this letter?
There was a discussion, and I was aware of that letter.
And did the other township supervisors concur in that after the discussion?
Yes, I believe so.
And then the next sentence says, the township will assume responsibility for drop-offs due to decrease in paving width. Is that correct?
That's correct.
What does that mean?
Well, that means that when they finish doing the paving, that we're responsible to finish the job by upgrading the shoulders. That was our responsibility, full responsibility, to upgrade those shoulders.
Did it also mean that it was your responsibility once the contractor left the site to inform the traveling public that a soft shoulder or low shoulder condition existed? You were going to assume responsibility.
Objection, Your Honor. The witness has already answered the question of what the responsibility was.
Overruled.
Please answer.
Could you repeat the question, please?
Did it also mean that the township was going to inform the driving public of the hazards that existed relative to this berm drop-off? It says the township will assume responsibility for drop-offs due to decrease in paving width.
Objection, Your Honor. The witness already testified that he didn't consider it a hazard. Counsel's putting words in his mouth now.
Overruled, Mr. Capuzzi.
We were going to do the work on the shoulders, and at that time there'd be a work zone. We would put signs up.
Well, at some point in time, on the 14th of October, the contractor is going to testify that they left the site. They took down all their signs. Any signs that would have informed anybody that there was a construction project underway, any signs that would have informed anybody that there was a low shoulder. What signs did you have the municipality place up to warn the traveling public of the hazard that had been created there?
We didn't have any signs.
Why is that?
I don't know.
Who is the individual for the township responsible for roadways?
Mr. Snyder?
And has Mr. Snyder been informed by you of the conversation that took place where you unilaterally determined that this would be an 18-foot roadway instead of a 22-foot roadway, and you would artificially create berm drop-offs on each side of the roadway?
Yes.
And did he do anything to place signs up to warn the traveling public after the construction project was taken down on October 14th of 1988?
No.
Do you know why not?
No.
Now, you've testified that you're a plumber. Is that correct?
That's correct.
What is Mr. Snyder's background?
I'm not sure exactly what he does.
Do you have any idea if he has any background in maintenance of roadways or engineering other than any on-the-job training he may have received with the township?
Other than what he's received in the township, no.
You were there for 8 years. In the 8 years you were township supervisor, you worked with the police force, yet you made a decision as to the safety of this particular roadway relative to berms. Is that correct?
Yes.
Did you think it was more prudent to contact the Commonwealth of Pennsylvania Department of Transportation, since they had drafted the specifications for this contract, to determine if your actions were prudent or reasonable?
That probably would have been a good idea.
But you didn't do that, did you?
No, sir.
And did you think it would be prudent to contact Mr. Snyder or even the township engineer prior to taking this action in order to see whether or not a more prudent or reasonable decision could be made relative to the roadway?
Well, everybody was out of town. I was called in and to look at it, and I made my decision. All the other supervisors were out of town at the time, and I got called over to take a look at it because I was the only one around.
Don't you have access to the township secretary's number so she can get other individuals if there's a concern about safety in the township?
Yes, I do.
And you didn't call her, did you?
No, I did not.
And she has access to where each of the township supervisors will be when they leave the community. Is that not correct?
That's not correct.
Oh, it isn't? What do you do in an emergency? Do you allow the gentleman who's in charge of the police department make decisions as to the roadway?
When there was one supervisor in town, then it was my responsibility to go out.
You may cross-examine.
Thank you. Mr. Gates, in your position as a supervisor, is that a full-time position?
No, it is not.
And your primary occupation is as of a plumber, is correct?
That's correct.
The roadway in question that counsel has so ably pointed out with these exhibits, if I may. This roadway here, that runs in front of the township building?
Yes, it does.
And for you to get from your home to the township building, it's necessary for you to drive on that roadway, correct?
Yes, it is.
Prior to the start of this contract, what was the width of that roadway?
18 feet.
And that was a roadway that you drove on a frequent basis, correct?
That's correct.
Counsel elicited from you that you were the commissioner or the supervisor in charge of the police department.
That's correct.
In your tenure as the supervisor in charge of the police department, did you ever receive any complaints from anyone concerning the shoulders along this roadway prior to paving?
No, I did not.
And to your knowledge, were there any accidents that occurred by vehicles encountering any drop-off on the roadway prior to this incident?
To my knowledge, no.
Now, when you were called out to the paving job, that was by Mr. Meyer?
Yes.
And in your discussions with Mr. Meyer, they were done at the scene of the paving job, correct?
Yes.
And your knowledge as of that time was that there was no problems with any of the shoulders prior to this paving, correct?
I object to the form of the question. He's already testified that he was shown other berm drop-off conditions by Mr. Meyer at the scene.
Overruled.
My question was, prior to this time, you had not received any complaints in your capacity as a supervisor concerning any berm drop-offs, did you?
That's correct.
Now, when Mr. Meyer showed you this berm and the drop-off condition, did Mr. Meyer advise you that you needed to place signs there?
No, sir.
And did Mr. Meyer advise you that there was any potential hazard?
No, sir.
That's all I have for you. Thank you.
Sir, let's go back to the date that you're out there with Mr. Meyer. Mr. Meyer tells you he's going to put a 2.5-inch overlay on the roadway. So you're going to have 2.5 inches minimum, the difference between the height of the berm and the roadway. Is that correct?
That's correct.
And then he explains to you that there are berm problems along the roadway, and he shows them to you. And it's been stipulated, because it's factual in this case, that there's a 5-inch drop-off existing on each side of this roadway where the plaintiff went off the roadway and came back onto it. Now, are you saying that that 5-inch drop-off is a condition that you had no reason to believe would exist after being shown by Mr. Meyer the substandard berm conditions, plus him telling you that he was going to put an overlay on the roadway?
I did not realize that that condition would exist as it exists. I realized that there would be 2.5 inches. I did not realize at the time that that would add to the drop-off that exists.
Even though he showed you that the berm was not level with the roadway surface and was substandard even at the time you were out at the accident scene?
That's correct. I don't know much about the roads. I could not visualize that.
Well, if you don't know much about the roads, why would you make a decision to go around a contract that specifically required a 22-foot roadway and reduce it to an 18-foot roadway and take the berms out which had existed before the construction job?
I believe that we were getting the same road distance width of the road, and that they would be extending it, and we would be getting the right road for the town. It's been that way for years. I assumed that it was appropriate and that we would fix the shoulders later.
Sir, you knew that you weren't getting the same road because the berms themselves were not there. After the construction project, you took no efforts whatsoever to place signing on the roadway, nor was any line striping done by the municipality or edge striping on the roadway after the construction project. Is that correct?
That's correct.
Thank you.
Mr. Gates, just a couple follow-up questions. The quantity of materials that were used to pave the roadway, did that change?
No, sir.
What happened by reducing the road from 22 feet to 18 feet?
We were able to increase the amount of paving, the length of the paving. So we were able to pave a longer stretch of road.
You did that with the understanding that the township would come back in the near future and redo the shoulders, correct?
That is correct.
Thank you.
Mr. Gates, the court has a few questions. The exhibit, plaintiff's exhibit, which is the October 12th letter, second paragraph, it had read that the township would be responsible for the drop-offs at that location. What did drop-off mean to you when you had received that letter? What did that mean to you?
It meant to me that there would be a slope down from the road, and that we would need to come in and fix the shoulder to pave and pave that section. That it was our responsibility to pave that section, not the contractors.
How far was the township building from the scene of the accident, from which is in plaintiff's exhibits 1 and 2?
About a half mile.
Okay, and is it in the direction you're looking at if you looked at the picture, or the other way?
I'm looking at this picture now. It would be from as I'm looking at it on the hill on the upper left.
And Mr. Capuzzi had asked you a question if you had been aware of any drop-off type accidents prior to this one. And my question is, when you made your answer to that, were you talking about the whole time period prior to the accident, or only the time period from the end of the repaving to this accident?
The whole time period.
Okay. Thank you, Mr. Gates. Call your next witness.
Dr. Eck, please state your full name for the record.
My name is Ronald W. Eck. My last name is spelled E-C-K.
And where do you reside?
I reside at 609 Valley View Street in Morgantown, West Virginia.
And what is your occupation?
I'm a professor of civil engineering at West Virginia University and also do consulting in the area of accident reconstruction and highway design.
What's your educational background?
The credentials of the expert witnesses are examined and accepted by the judge and the attorneys.
Dr. Eck, could you please inform the jury what materials you have reviewed relative to doing the reconstruction that you are here for today?
Yes, sir. I reviewed the police accident report. I reviewed a number of photographs, both taken at the accident scene as well as taken at the accident site sometime after the accident. I've reviewed several deposition transcripts, and I've reviewed the defendant's expert report.
And Doctor, have you reviewed these materials relative to my request that you do a reconstruction of the accident involving Robert Wilson, which eventually led to his death in October of 1988?
Yes, sir, I have.
Doctor, and as a result of the materials you've reviewed, were you able to perform and prepare an accident reconstruction relative to Mr. Wilson's death in October of 1988?
Yes, sir. I would call it a partial reconstruction, yes.
And what were your findings, opinions, or conclusions relative to the analysis that you have done in this matter, Doctor?
I concluded that the accident occurred as has been previously stipulated to, as Mr. Wilson was passing three vehicles, specifically as he was passing the lead vehicle, which was a dump truck, the left tires of his pickup truck dropped off the pavement onto the shoulder. As he attempted to regain the pavement, I should note there was a 5-inch edge drop-off between the shoulder and the pavement. As he attempted to regain the pavement, he overcorrected in terms of steering and moved across the roadway from left to right. Then, in attempting to get onto the road, again steered in the opposite direction and went from the right side of the road to the left, running off the road and striking a utility pole. And subsequently the vehicle overturned and he was killed.
Doctor, could you please define what a yaw maneuver is and whether one was involved in this particular accident from your review of the photographs as well as Dr. Kilarowski's report?
Yes, sir. A yaw mark or yaw maneuver is a mark made by a tire that is both rotating and sliding sidewise, as frequently occurs in cases where, like this, where a vehicle may leave the roadway and coming back on the roadway, there is a sharp steering maneuver. And in answer to your question, yes, there were yaw marks evident on the roadway after this particular incident.
Doctor, were you able to make give an opinion as to what length this yaw mark would have been after reviewing the photographs that were supplied of the accident scene? And specifically, I'm showing you Exhibit 1, which shows the overturned vehicle and the roadway in question, and Exhibit 2, which has various skid marks or yaw marks, I don't know which they are, existing on the roadway.
And your question was I able to
make a
measure...
determination as to the measurement of those yaw marks?
No, sir, I was not.
Now, you were never at the scene, were you?
No, sir, I was not.
Because by the time I had contacted you relative to do this reconstruction, the roadway was no longer in the condition that it's in, showed in these photographs. Is that correct?
That's correct. The shoulders had been brought up such that they were flush with the pavement surface, and the pavement striping had been placed on the pavement.
And as far as the yaw marks that are referenced in another report and may be referenced in your report, does a photograph give you the ability to measure a yaw mark such as the photographs you've seen?
A photograph could, if it were photogrammetrically correct and taken with appropriate measurements and reference points. In this particular case, no, it would not be possible just based on the photograph because of the perspective of the lens. It would not be possible to measure lengths or angles
Doctor,
correctly.
I'm going to show you the photograph which shows the vehicle overturned. There's testimony that that vehicle was 80 feet away from the broken telephone pole. Are you able to tell that from looking at the photograph?
Not simply from the photograph, no, sir.
Is there a foreshortening shown in the photograph of distance because of the angle of the camera?
Yes, sir.
Is that the reason why you weren't able to make a measurement as to the yaw marks?
Yes, sir.
All right. Now, as a result of your findings and the stipulated fact that there was a 5-inch berm drop-off that existed on each side of the roadway, have you checked the relevant engineering literature to determine whether or not that is accepted standards or accepted generally for roadway maintenance and repair as far as the difference in height between the roadway and the berm?
Yes, sir, I have.
What have you reviewed relative to the engineering literature on berm drop-offs in order to make your decision or give your opinion in this matter?
I've reviewed the results of studies done by Klein and Johnson as well as Ivy at Texas A&M, Texas Transportation Institute, which have looked at the effect of different levels or different heights of vertical drop-offs on driver performance and on vehicular behavior as drivers attempt to get back on the roadway. And
what were those findings, Doctor?
Essentially, those findings are that any drop-off greater than about 2.5 or 3 inches in height can pose a serious hazard to motorists. It can cause them to go out of control as they attempt to regain the pavement.
And what is the nature of the dynamics of how that occurs, Doctor? As a vehicle leaves the roadway, does the literature explain what the normal reaction of a driver is upon leaving the roadway?
Yes, sir.
And what is that?
The normal or instinctive reaction is as the tires leave the roadway, the drivers instinctively attempt to get back on the pavement and therefore turn the steering wheel sharply to in an effort to bring the tire back up onto the pavement.
And what occurs as a result of that, Doctor?
As a result, there's essentially what we might call an overcorrection in steering, in that by the time the tire does get up over the lip or the drop-off and onto the pavement, the steering wheel or the steering is overcorrected and the vehicle shoots across the lanes of traffic.
Doctor, do you have an opinion within a reasonable degree of engineering certainty whether or not the 5-inch drop-off, which existed both to the left of the roadway surface and the right of the roadway surface, was a substantial factor in causing the accident in question?
Yes, sir, I do.
And what is that opinion?
My opinion is that the 5-inch vertical drop-off that we had in this case was a substantial factor in causing the accident.
Doctor, did you review the signing and the line striping that existed on the roadway at the time of the accident?
Yes, I did.
And did you see any no passing signs anywhere evidenced from any of the testimony or any of the documents supplied in this case?
No, sir, I did not.
Did you see any line striping down the center of the roadway other than the dots that are shown on the photographs, the yellow dots?
No, sir, I did not.
Did you see any end striping to warn travelers that the roadway ended, which would have been located right next to the 5-inch berm drop-off on either side of the roadway?
The edge striping?
Yes.
No, I did not.
So there's no edge striping that you saw on the roadway, there's no center line on the roadway, and there's no warning signs warning of a low shoulder. Is that correct?
That is correct.
Doctor, do you have an opinion within a reasonable degree of engineering certainty whether the signing and the line striping that existed on the roadway was reasonably safe for the traveling public and met state and federal guidelines relative to signing and guidance relative to line striping?
Yes, I do.
What is that opinion, Doctor?
My opinion is that the signing and marking on this section of roadway was not reasonably safe and did not meet appropriate guidelines and standards.
Doctor, do you have an opinion as to whether or not that signing, or lack of signing, and that lack of line striping was a substantial factor in causing the accident and the injuries to Mr. Wilson?
Yes, I do.
And what is that opinion, Doctor?
That opinion is that the edge drop-off and the improper signing and marking was a causative factor in the accident.
Doctor, you've heard testimony in the case that some of the vehicles may have been traveling 45 miles per hour. Those are the vehicles that Mr. Wilson is passed on the date in question. Is that correct?
That is correct, yes, sir.
Were you ever able to come to an exact speed that Mr. Wilson was traveling relative to your accident reconstruction?
No, sir.
And are you aware that the speed limit on the roadway was 35 miles per hour?
Yes, sir, I am.
And taken as a given that the speed limit was 35 miles per hour, that there was a 5-inch berm drop-off on either side of the roadway, and that as he attempted to pass going downgrade, his vehicle left the roadway and the two left wheels went off of the roadway, and his vehicle went out of control, eventually causing his death. Do you have an opinion within a reasonable degree of engineering certainty whether or not the roadway defects, specifically the berm drop-off and the signing or lack thereof, as well as the line striping, was the causative factor in his injuries and death?
Yes, I do.
And what is that?
That is that the edge drop-off and the improper signing and marking were causative factors in Mr. Wilson's accident.
You may cross-examine.
Dr. Eck, as part of your qualifications in your engineering, you're also a human factors expert, am I correct?
No, sir.
In your report, you talk about that, and in your original deposition transcript, you talked about human factors as being a consideration.
That's correct.
Okay. This accident occurred on October 20th, 1988, but your report's not done until April 21st, 1991.
That's correct.
30 months after the accident.
That's correct.
In the very first paragraph, and do you have a copy of your report there?
Yes, I do.
And, Your Honor, may I approach the witness, please?
Yes, you may.
May I take a look at what you brought in your file, please?
Certainly.
Thank you. Let me call your attention to the first paragraph of your report. And it says that the attorney that hired you, in this case Mr. Rosenthal, asked you to determine the cause of the accident. Is that correct?
That's correct.
And to determine the cause of an accident, you have to look at a lot of different factors.
That's correct.
One of those factors being driver behavior.
That's correct.
Speed limit was 35 miles per hour.
Yes, sir.
In doing any type of reconstruction and any type of engineering analysis, you have to be familiar with the motor vehicle code. Is that correct?
That's correct.
And if the speed limit is set at 35 miles per hour, is a vehicle permitted to go 45 miles per hour?
Legally, no, sir.
Let me refer you to page 2 of your report. You give some of the geometric conditions that you found? Straight roadway, slope gently downward, several hundred yards of sight distance?
Yes, sir.
That would be considered excellent sight distance, wouldn't it?
I would say good sight distance. I don't know if I'd call it excellent.
Wasn't poor sight distance.
No, sir.
You listed documents that you reviewed,
Yes,
and you have 7 items on your report, correct?
that's correct.
You testified a few minutes ago that you reviewed several depositions.
That's correct.
However, looking at your report, you only list 2 depositions.
That's right.
You also stated that you looked at the report of Dr. Kilareski.
That's correct.
And did you note in that report that Dr. Kilareski examined 29 items of information, documents relevant to this case?
I believe that's correct, yes.
Did you note in there that Dr. Kilareski reviewed 12 depositions,
Yes, sir.
and you only reviewed 2?
That's correct.
You never visited this site, did you, Doctor?
No, I did not. It had been changed by the time I was involved in the case.
Had the grades been changed?
No, sir.
So not every condition was changed there, was it?
That's correct.
You spoke about the yaw maneuver and the yaw marks.
Yes.
Counsel asked you if you could get that from the photograph.
Yes.
And your testimony was no?
That's correct.
However, item number 1 in your report of the items examined was the police accident report.
That's correct.
Did you note in there where the officer measured these yaw marks and listed that in the report and considered that part of the diagram?
It's my recollection that those measurements were simply his paced off or estimated measurements. They were not actually measured with a measuring device. And I would find, or have found based on my experience, that those measurements typically can be off by a considerable amount.
Well, Doctor, didn't you note on the first page of the police accident report where it asked whether it was estimated or measured that the police officer checked off measured?
I don't recall that, no.
Let's talk about the accident itself.
Yes, sir.
You mentioned 2 maneuvers, the vehicle going off to the left, coming back to the right,
Yes, sir.
then going off to the left again. Let's, if I may, in Dr. Kilareski's report, there's a diagram. Did you see that diagram?
Yes, sir.
Do you have any reason to believe that this diagram is not accurate as to what was at the scene of the accident on the day the accident occurred?
Which diagram are you showing me?
It's Defendant's Exhibit 3. It's the Figure 2 highway geometry of Old Route 115.
Yes, sir.
Now, based on what you testified to earlier, that Mr. Wilson was abreast of the dump truck.
That's correct.
That's based on witness statements.
That's right.
Those witnesses testified that they were going 45 miles per hour at that point in time.
That was their testimony. I was not able to establish whether they actually had looked down at their speedometer or whether that was just their thinking of what they were traveling at that time.
However, the testimony was of more than one individual.
That's correct.
However, the sequence of events don't begin there, do they?
The sequence of the passing maneuver?
Of the whole passing maneuver.
That is correct.
Now, can you tell in this diagram or from the materials that you reviewed approximately where that passing maneuver began?
He's taken it as a given that the diagram prepared by Dr. Kilarski correctly and accurately depicts where all maneuvers began, whereas the testimony of the witnesses is the basis for any discussion of that.
I don't think he's doing that. I think you can continue. Witness, you can answer that question if you're able to.
Are you able, from the materials that you reviewed, ascertain where the passing maneuver first began?
Not exactly, no, sir.
Testimony from one of the witnesses says approximately the crest of the hill.
That's
They came
correct.
over the crest of the hill. Correct?
That's correct.
And on this diagram, the crest of the hill is back up in here. Am I correct?
That's correct. The diagram shows 800 feet to the left of the drawing.
So back up in here.
That's correct.
So if we were to mark that as A, would you do that for me, please? Just put A approximately where the maneuver started.
I'll show it here on the far left side.
So at point A, Mr. Wilson,
The attorney for the defense uses the road geometry diagram as a way to reconstruct the accident.
let's talk about the maneuver itself, the passing maneuver.
Yes, sir.
In your estimation, was that prudent?
It was not unreasonable under the circumstances.
Well, Doctor, I look at your report on page 6, which in hindsight may not have been prudent, talking about the passing maneuver.
That's correct.
And it's your testimony today that that passing maneuver, giving the darkness, three vehicles in front, speed in excess of the speed limit, that was a prudent maneuver?
No, I'm saying it was not unreasonable under the circumstances of a newly surfaced roadway, which studies have shown that motorist speed tend to be higher on a newly resurfaced roadway than they were on the original roadway. Given the relatively good sight distance in the vicinity and the lack of markings indicating that this was a no passing zone.
So then it's your testimony that it was a prudent maneuver?
No, sir, I'm saying it was not unreasonable under the circumstances.
But was it prudent?
It may not have been under these
Thank you,
the
that's all I
situation.
have.
No further questions.
One question from the court, Dr. Eck.
Yes, Your Honor.
Last year in this court, we had a similar trial where one of the expert witnesses came in and, using a computer in some way, was able to make a determination with respect to accident reconstruction, determining the length of skid marks and coming up with speed. Was that anything that you had entertained in this or had used in this case?
No, sir. Because of the lack of information we had in terms of the length of the tire marks, skid marks, and so forth, it was not possible to do that in this case.
Thank you.
Plaintiff rest.
Clerk, at this time, the defense would move for a compulsory non-suit. This time, defense will call Dave Meyer. Mr. Meyer, will you tell the jury what your occupation is?
I'm president of Meyer Paving Company.
And did Meyer Paving Company perform the repaving of Old Route 115?
Yes.
And as part of your contract, were you required to pave 22 feet of roadway?
That's correct.
Did you, in fact, pave a width of 22 feet on Old Route 115?
No, we didn't.
And why did you not?
The shoulders were not up to standard as originally agreed upon, so we, in discussion with Mr. Gates, decided to go with 18 feet.
When did that discussion take place?
On October 11th,
And what year was that?
1988.
And as a result of that discussion, did you make notes in your field diary?
Yes, I did.
And based on those field notes, did you then dictate a letter to the township?
Yes.
In your conversations with Mr. Gates at the location, did you advise Mr. Gates of the problem of the drop-off?
Yes, I did.
Did Mr. Gates ask you any questions about the drop-off condition?
No.
Did Mr. Gates at any time express a concern for the size of the drop-off?
No.
Did you subsequently receive a letter which has been introduced here from the township?
Yes.
And the work that was performed for the township, that was done pursuant to contract?
The original contract was for 22 feet wide, and we did it at 18 feet wide.
And on what basis did you make a change in that contract?
I pointed out the drop-off conditions to Mr. Gates and presented him with some options that we could do since we couldn't do the 22-foot width, and he decided to go with the 18 feet.
And when your paving was done, what were you required to do at that point in time?
Nothing. We picked up our signs, our equipment, and we were done with the job.
And the representation made by the township and what's in this letter here of accepting responsibility, is that what transpired on the day at the scene with Mr. Gates? Accepting responsibility for the 18 feet of paving?
That's correct.
And for the drop-off condition?
That's correct.
That's all I have.
Mr. Meyer, you knew that the drop-off condition was a potentially dangerous and hazardous condition, and that's why you sent a letter to the Township Board of Supervisors, and that's why you requested a letter. Is that not correct?
I know that there were some drop-off problems, and when we put the additional 2.5 inches of overlay on, there could be some more serious problems. That's correct.
2.5 inches magnified the problem, and you were worried about liability, and therefore you basically asked the township to assume responsibility for drop-offs due to a decrease in paving width. Is that not correct?
That's correct.
But even knowing that dangerous condition existed relative to the berms, you removed all your signs and you left the roadway without any warning to the public about what potential hazards existed there. Is that not correct?
That's correct.
Did you have low shoulder signs or construction zone signs up while you were doing work?
We had construction signs up and working signs.
And that was there for warning purposes to make sure that either your people didn't get injured or no one went off the roadway into your construction area. Is that correct?
That's correct.
And when you left that roadway with a 5-inch berm drop-off on either side of the roadway, you didn't leave any signs, you didn't leave any pavement markings, you just left. Is that correct?
That's correct. We weren't responsible for the striping or the shoulder work.
No, you made an agreement with the municipality that they would assume responsibility. You have no idea one way or the other whether you were legally responsible. Is that correct?
Objection, Your Honor. Asking for a legal conclusion.
Granted.
The only agreement you knew of relative to legal responsibility was the agreement that you made with a township supervisor who was a plumber out at the scene on October 11th of 1988. Is that correct?
Objection, Your Honor. Same thing, legal basis.
Granted.
Thank you. Did you know Mr. Gates' background?
No, I did not.
Did you inform him of any potential hazards that could be created by this problem?
I told him that there were some drop-off problems, and that's why we couldn't pave at 22 feet wide.
That's all you told him?
Yes.
No further questions?
No redirect.
Mr. Meyer, court has a few questions. You had mentioned that when you met with Mr. Gates, you explored some options with him with respect to what was going on here. What were those options that you did explore with him?
Well, the one option was going with the 18 feet and giving him about a quarter mile extra in length of paving. Another one was that we could come back the next construction season after they took care of the shoulders and go to 22 feet.
And do you recall today, I know it's a few years past this, but do you recall when you finished the construction work on this job?
Yes, it was October 14th, 1988.
Okay, thank you.
Defense calls Dr. Kilareski. Dr. Kilareski,
You're under oath.
I'd like to remind you that you were qualified this morning. We took Mr. Meyer out of order to accommodate him, and you've been qualified as a highway transportation engineer and an accident reconstructionist. And we'd ask you to testify with that in mind. Now, Dr. Kilareski, by whom were you requested to do an analysis of this accident?
By you, sir.
And when that assignment was given to you, were there any limitations placed upon you by me?
No, sir.
And as a result of your analysis, did you prepare a report?
Yes, I did.
In your report, you reviewed a large number of documents, am I correct?
Yes, sir.
And I believe on page 2 and 3 of your report, you tell the jury the total number of items that you reviewed?
We reviewed 29 documents.
And tell the jury how many of those documents were depositions?
11 were depositions.
Did you also make site inspections?
Yes, sir. I was on the site 3 different occasions.
And when you were at the site, did you tell the jury what you did relative to this accident analysis?
I measured the dimensions of the roadway, determined the roadway geometry in the area of the accident.
Tell the jury what the roadway geometry was in the area of the accident.
The roadway is a tangent section of highway. It's 2 lanes in width. During my visit, I measured the roadway width from edge to edge, approximately 18 feet. There were shoulders at that time during my visit. The shoulders varied from 2 to 3 feet in width.
And doctor, did you prepare some diagrams as a result of this analysis?
Yes, I did.
I'd like to call your attention to figure number 1 of your report. Could you explain to the jury what this shows? Doctor, would it help you if you came down from the witness stand and
Sure.
explain to the jury, with the court's permission?
This is a straight line diagram.
Excuse me, doctor. How about we stand like this? And if you stand there.
Thank you.
Doctor, you have to step back just a little, if you would, please.
This is a straight line diagram of the accident site. This is the facility, the 2-lane facility. The intersection that was discussed earlier, the intersection of Market Street and of the route, is at this location. The approximate crest of the hill is in this area. The roadway is approximately 8% downgrade from this location down to the area of Market Street. From the crest of the hill to this area is approximately 800 feet. And then from this location, Market Street, the intersection, to the utility pole in the final resting position is another 800 feet approximately.
Thank you. You may take your seat, doctor. Doctor, did you review the police accident report?
Yes, I did.
And in that police accident report, did you review the measurements and police accident diagram?
Yes, I did.
Based on the information that you had available to you, were you able to reconstruct this accident?
Yes, I was. I was able to do that.
Could you explain to the jury, first of all, what a reconstruction is and then how you did this reconstruction?
A reconstruction is when an engineer will take the facts that are available, such as the dimensions from the police report, the dimensions that we measured in the field, statements from the witnesses, and then using engineering and scientific expertise and analysis, piece together the events of the accident.
Doctor, did you do that in this case?
Yes, I did.
Could you explain to the jury how you did this reconstruction and what information you used?
Well, I had photographs of the accident scene, and based on the measurements that I had in the field, I was able to determine 4 distinct reference points in the field. And then I was able to determine that those reference points were in the photographs at the time of the accident. And since I had 4 points and the dimensions of those 4 points, I was able to use photographic interpretation to accurately measure the yaw marks on the photographs, the location of the final rest of the vehicle and the utility pole. So I had some very accurate measurements then of the accident scene. With respect to the police report, everything was in order, so I was very confident in the dimensions that I had of the yaw marks and the final rest of the vehicle.
Now, based on that, were you able to calculate the speed of the vehicle at the point of impact and prior to it?
Yes, I was.
And would you explain to the jury how you did that? And if it would be helpful to use one of the diagrams, please feel free to do so.
I can probably get by with, well, excuse me, let me use the photograph.
When you say photograph, you're talking about Plaintiff's Exhibit 1. Let me hold it for you, Doctor.
I normally work backwards when I'm trying to determine vehicle speeds. Not to be facetious, but I know the speed of the vehicle at rest is 0 miles per hour. I knew it was 80 feet from the pole to the final resting position of the vehicle, so I was able to determine through normal deceleration rate what the speed of the vehicle was when it left the utility pole. I also knew the weight of the vehicle, and knowing the approximate weight of the vehicle and the type of the utility pole, I can make a determination of how fast the vehicle was going to shear off the utility pole. In this case, the vehicle was traveling approximately 35 to 40 miles per hour when it sheared off the utility pole. I was able to measure the radius of the yaw marks, and knowing that radius and something about the coefficient of friction for a new pavement, I was able to determine the speed of the vehicle during the yawing maneuver. And that speed was a minimum of 60 miles per hour. Knowing the speed of the vehicle as it entered the yaw marks and determining where the three vehicles were on the grade and the time distance it would take for a vehicle to pass three other vehicles, I was able to determine that the speed of the vehicle during the passing maneuver was approximately 65 miles an hour minimum, probably 70 miles an hour.
Now, Doctor, you were aware of the edge drop-off, am I correct?
Yes, I was.
And in your analysis of this accident, did the edge drop-off become a factor?
Yes, it did.
And would you explain to the jury what that factor was?
Well, the factor was that the edge drop-off was approximately 5 inches. The significance of that is at a speed of 70 miles an hour, 65 to 70 miles an hour, with a 5-inch drop-off, it didn't matter whether it was 3 inches or 5 inches. There was a serious condition here that a driver at 65 miles an hour could not control his vehicle when he encountered a 5-inch drop-off.
Doctor, you've heard testimony that the posted speed limit was 35 miles per hour.
Yes.
And given the facts in your analysis, do you have an opinion within a reasonable degree of engineering certainty as to what the approximate cause of this accident was?
Yes, I do.
And would you kindly tell the jury what that opinion is?
Well, in my opinion, the speed limit was 35 miles per hour. The queue of vehicles was already traveling at 45 miles per hour, and that was unreasonable for this driver to attempt a passing maneuver at night when he was already going above the speed limit.
Thank you, Doctor. That's all I have.
It's very interesting that you're testifying today as to your knowledge about the berm drop-off, because I have a 23-page report that you prepared, and I'm wondering why nowhere in the 23 pages do you reference a 5-inch drop-off. Can you explain that to me?
Yes, because I'm aware of the 5-inch drop-off, but in my opinion that the approximate cause of this accident was the excessive speed, and that at that speed of 65 to 70 miles per hour, it was almost irrelevant whether it was a 3-inch drop-off or a 5-inch drop-off.
You don't say that in your report, Doctor. And you just told me when you do an accident reconstruction, the important thing to you are the facts. Is that correct?
That's correct.
Then answer me now. Was it at Mr. Capuzzi's direction or at your own that you deleted the reference to a 5-inch berm drop-off on both the right side of the roadway and the left side of the roadway for the full distance involved in this accident?
Mr. Capuzzi has
nothing to do with my writing of the report. I write as an independent witness.
Fine. Then explain to me why you don't even mention it in your report. You've got 23 pages of literature in there. You're talking about Dr. Ivey, and Dr. Ivey, who you quote for purposes of being the expert on what a utility pole crash damage is, isn't he one of the foremost experts in the world on berm drop-offs?
Yes, and as I stated earlier, in my opinion, the proximate cause of this accident is excessive speed and not necessarily an edge drop-off problem.
You still don't have an explanation as to why you didn't mention the 5-inch drop-off in the 23-page?
No.
Doctor, you did a reconstruction. And in doing your reconstruction, you used photographs to determine comparative speeds as one of the things you say in your report. Is that correct?
Yes.
Dr. Eck testified that the photographs that we've looked at show a foreshortening. And by foreshortening, he says when he looks at the particular photo, which is photo exhibit 2, he's not really able to tell what the distance is between the telephone pole and the tree because of this foreshortening effect. Do you agree with him on that?
Yes.
Okay. Do the photographs have a foreshortening effect so it makes it difficult to tell distances?
Well, I'm looking now in my notes, I had more than those 2 photographs. We had a packet of approximately 14 or 15 photographs. And as I stated, based on the site visit, I was able to determine 4 reference points, and using those 14 photographs, piecing them together, we were able to determine the length of the yaw marks.
The 2 photographs that you introduced into evidence certainly don't show that, do they?
Those 2 photographs, no. As I said, I used 14 photographs to piece it all together.
Okay. I'm just saying the photographs that your counsel showed you, the 2 photographs which showed the foreshortening, and those 2 photographs, they don't show that, do they?
No.
And you admit that when you do a reconstruction, you're trying to take all the pertinent facts to an accident and make a determination based upon all pertinent facts. Is that correct?
Yes, sir.
And yet, for some reason, in the 23 pages of your report, you managed to delete the references to the 5-inch berm drop-off on both sides of the road, which has been stipulated to by counsel in this case, correct?
Correct.
We rest. Thank you. You've all heard the testimony of the various witnesses. There's certain facts that are totally agreed to by all sides. The one fact is the municipality was aware that they had a contract to do a 22-foot roadway, and there would have been no berm drop-off. Gentleman who was a township supervisor who testifies that he has no knowledge really about doing roadways. He's a plumber by trade. Makes a decision. We're going to do this at 18 feet. And they create a 5-inch berm drop-off on either side of the roadway. You've heard various experts testify. The experts all were in agreement. A 3-inch berm drop-off or greater is a serious hazard for operators of vehicles. We're driving on a newly constructed road or resurfaced road. You've heard the testimony that when you're driving on a road like that and you see no signs for no passing or no signs to warn you of potential hazards, operators of vehicles normally drive at a better speed. They drive at a better speed than they normally do because a comfort zone exists because you're on this new surface and there's no potholes and there's no problems and you feel good. And unfortunately, what was created here was a trap. Because while there's testimony that the plaintiff's decedent, Mr. Wilson, was traveling over the speed limit, there's also testimony, clear and unrebutted, that he went off the roadway to the left in a passing maneuver. It's not an improper maneuver here. There's nothing that shows this is not a no passing zone. And we all pass when vehicles are traveling at around the speed limit or even a bit higher. But what he encounters is a 5-inch berm drop-off, and he cannot regain control of his vehicle. Dr. Eck has testified, and so has Dr. Kilarski, and they're both in agreement. That 3-inch berm drop-off is a problem, whether you're going 35 miles an hour or whether you're going a higher speed. And we have somebody who's dead today, and he's dead today because he was trapped. He's passing in an area that clearly could have been marked. He's passing in an area where the township has a responsibility. Township has a responsibility and a duty to provide reasonably safe roadways. If it was your child, if it was your father, if it was your sister, they have the same duty to that person as they have to Mr. Wilson. There are duties that all parties have. Mr. Wilson has a duty to drive reasonably safe, and the judge is going to tell you what his duties are. But clearly there are various duties that are competing here, and that means what you must do under the law. The township did not meet their duty. The paving company, they want to get their job done. They know that this is dangerous. They go get documents. They get letters. They send a letter, have the township send them back a letter, because they know that there's going to be a liability problem here. And what do? They try to protect themselves with letters. But who protected the operators of vehicles on this roadway? Who informed the operators of vehicles on the roadway about the 5-inch berm drop-off on either side of the road? You have a newly asphalted roadway and it's black. It's a blacktop roadway. They don't put a center stripe on it. They don't put edge line markings on it. You're driving down the roadway. It's dark. It's early in the morning. You're going to work, and you expect that you can be able to drive on the roadway. And what you do is you come into a trap. And you try to rectify that problem, and we've all experienced this. You try to steer your vehicle back onto the roadway because you don't want to be off the roadway. And unfortunately, an overcompensation occurs, and a death results. What would it have taken to put a low shoulder sign up? What would it have taken to get competent people to review the decision on whether or not we should go forward with the construction or not? Because in reality, you don't want a situation to exist where somebody who has no background relative to doing roadway work and roadway repairs and roadway improvements makes a decision that's in contravention of the contract, in contravention of the specifications that PennDOT's provided. They're provided for a reason. They're provided for safety. And we all can expect the same safety concerns for ourselves and for operators of vehicles that we would want anyone else to have as long as the law says that that is what is required. So you have a circumstance where you're going to be asked to weigh what occurred in this case. And you're going to be asked to look at the overall picture. It's not micro. It's not, hey, somebody was traveling too fast for conditions and they killed themselves. And somebody had a roadway defect, and so what? You know, we were going to get to it eventually. No, you have to view this case in the whole. And when you view the case as a whole, we all pass vehicles on a roadway. Whether we passed one vehicle or whether we passed 3 vehicles, we're permitted to pass. And we have under the law, and the law is clear, and the judge will tell you what the law is, we have the duty of a commonwealth or the duty of a local municipality to provide a reasonably safe roadway. It wasn't provided here, and the contractor protected themselves with some letters. Nobody protected Mr. Wilson.
Your Honor, may it please the Court. Ladies and gentlemen, when you came into this jury box today, prior to the start of this case, the judge gave you several instructions. One very important instruction that he gave you was not to leave your common sense at that door when you walk in here. However, I submit that what you're being asked to do is to discount that common sense, set it aside. What can we say positively about this case? Speed limit, experts admit, everyone admits, in the diagram it's posted, 35 miles per hour. That's the speed limit. It's there for a reason. Plaintiff would have you believe that there only one duty exists in this case. The duty that goes to the contractor and or the municipality. They would have you forget about the duty Mr. Wilson has. This is the result, the sheared pole. The other exhibit shows you the vehicle and the death. However, to accept what plaintiff has told you, the municipality must provide a reasonably safe road, means that you have to forget about the events that preceded that drop-off. I know everyone wondered why I was having Dr. Eck make marks on the diagram, A, B, C. Well, to buy plaintiff's theory, Nothing occurs until we're at C when he first goes off the roadway. What happened between A and C? That's the issue. That's where the event starts, back at A. Not down here at C where the drop-off is. That vehicle went from A to C and then off the roadway. What put that vehicle out in the oncoming lane of traffic, and what put that vehicle over the edge on the other side? There's been no testimony, absolutely zero, that there was any condition of the roadway that caused Mr. Wilson's vehicle to go off that roadway other than Mr. Wilson's driving abilities. Ladies and gentlemen, I submit to you that given the facts of this case, and in spite of the tragic death, that you cannot forget. And the testimony is that the cause of this was the speed and the driver's ability not to handle that speed. Dr. Eck, when asked if that was a prudent decision, hemmed and hawed, finally admitted it wasn't. I submit when you go into that jury room, there can only be one verdict. And that verdict's got to be in favor of both the contractor and the township supervisor in the township, and that the sole cause of this accident was Mr. Wilson's driving ability. Thank you.
Members of the jury, in a few minutes you're going to be deciding this case. It's your duty to decide the case based upon the testimony you've heard today and the law that I will give you. In doing so, in making your decision, it's your duty to set aside any and all sympathy you may have for any party in this case, as well as setting aside any prejudice you may have for any or against any party in this case. I instruct you that the plaintiff, the estate of Robert Wilson, has the burden of establishing by a preponderance of the evidence that the defendants were negligent. Again, the defendants are Lincoln Township and Meyer Paving. Conversely, the defendants have the burden of establishing by a preponderance of the evidence that the plaintiff is negligent. Now, I've just mentioned a couple of terms, and let me explain those. Negligence is one term, and negligence is absence of ordinary care which a reasonably prudent person would exercise under the circumstances. Negligence can either be an act or a failure to act when there is a duty to do so. Now, there are basic elements of a cause of action of negligence, and there are four of them. The first is there has to be a duty on the part of the defendant to conform to a certain standard of conduct. And I'll explain those duties in just a second. Secondly, there has to be a breach of that duty by the defendants. Thirdly, there has to be a close causal connection between the conduct of the defendants and the resulting injury to the plaintiff. And lastly, there has to be an actual loss or damage to the plaintiff. Now, the parties have stipulated the last element, which is the death of the plaintiff. Now, with respect to duty, what the duties are in the case, it is the duty of the defendants to provide for a reasonably safe roadway for ordinary travel. Thus, if you find by a preponderance of the evidence that either of the defendants violated this duty, then you must find that defendant negligent. With respect to the plaintiff, a violation of the Motor Vehicle Code is considered to be negligence if it is the cause of the accident. Thus, if you find by preponderance of the evidence that the plaintiff's decedent violated any provision of the Motor Vehicle Code and that such a violation was a substantial factor in causing the accident, then you must find that the plaintiff was negligent. Now, you've heard a number of witnesses here today, two of which were expert witnesses. Now, a witness who has special knowledge, skill, experience, training, or education in a particular profession may give his or her opinion as to any matter which he or she is skilled to deal with. In determining the weight to be given to that expert witness, you should consider the qualifications and reliability of the expert and the reasons given for the opinions. You are not bound by an expert's opinion simply because that person is an expert. You can accept it or reject it as you can with any of the witnesses you've met and heard today. Give any of the witnesses' testimony the weight that you deem it proper, the weight that you feel it is entitled to. Last thing is you will be getting a verdict slip, and it will read, based upon what you have heard, do you find, and there's listing for three things there, the municipality, the contractor, and the driver. And over here there's boxes where you can check either negligent or not negligent. Your first consideration is you should consider the municipality and the contractor and make a determination whether both or either one of them or neither of them were negligent or not. If after you make your deliberations and you find both of them, if you find both of them not negligent, stop your deliberations and you can come back in, because then the case is over. Okay? If, however, you find one or both negligent, then you move on to a consideration of the driver and make a determination whether the driver is negligent or not. After you've done that, I want you to tally up the percentages or the weight that you can give to the relative negligence of all parties. That those percentages have to equal 100%.
Members of the jury, I'd like you to follow my tip staff, Mr. Kelly, out to the jury deliberation room.
The driver
he was already going 10 miles an hour.
I know.
I guess part of my black pavement with no markings on it all. It's the driver's responsibility. If he was an elderly gentleman too, probably.
Yet he knew that the hazard did exist. So that's my definition of negligence on his part.
In fact, when he got a letter,
he put the blame on the municipality. He may have been wrong, but I mean, I would say it's more the municipality than the contractor.
I'm talking about a safety hazard.
But he's talking to the municipality's representative.
But he can see that, you can plainly see that wasn't the case when he was driving on the road.
Not necessarily. It's 6:30 in the morning. It's dark. It's brand new black asphalt. You have no idea what the color of the road was next to it. It looked to me that it was dark.
Grassy to me.
No, it was dark. Right off the pavement, it was
But a new
scattered black.
paved road without any markings or any signage. And you would feel confident taking off and passing somebody and flying down that highway 60 miles an hour.
Which we all agree there should have been. The fact is, when he walked off the job site, he knew there was a hazard.
The jury has reached a verdict.
Do we have a verdict?
Yes, Your Honor.
Okay, let me ask the question then. With respect to the municipality, do you find the municipality negligent or not negligent?
Negligent.
With respect to the contractor, do you find the contractor negligent or not negligent?
Negligent.
With respect to the driver, do you find the driver negligent or not negligent?
Negligent.
With respect to the municipality, what percentage of negligence do you assign to the municipality?
37.5%.
With respect to the contractor, what percentage of negligence do you assign to the contractor?
5%.
And with respect to the driver, what percentage of negligence do you assign to the driver?
57.5%.
Thank you. Court's dismissed.